You were with the same colleagues for the first 11 years or so?
About 10, 10 and a
Yeah.
half, something like that, sure.
Did the practice change as the composition of the court changed?
Well, not the practice.
Okay.
The procedures really were the same.
Okay.
So, what changed, of course, is as the makeup of the court changed, so did its perspective, because new members brought new perspectives, new orientations to the court. So, Chief Justice Wilentz was replaced by Chief Justice Poritz. Justice Clifford was replaced by Justice Coleman. I'm not sure. I think Justice Handler left next and was replaced by Justice Virginia Long. Justice Pollock might have been replaced by Justice LaVecchia. I'm not sure. Justice Garibaldi might have been replaced by Justice Vernero. My successor was Justice Albin. So one at a time, as members of the Wilentz Court left and new members were appointed, it was understandable and appropriate that the perspective of the court changed. The first case decided after Chief Justice Poritz was appointed, in fact, was a case in which Chief Justice Wilentz had passed away before I could circulate the majority opinion. And so, because he passed away and his death intervened, we had to re-argue the case with a new court, because we only had 6 members of the Wilentz Court on the case, and we re-argued it, and the result changed. But that was not surprising. So many of our cases were close cases. That's why they got to our court. They involved very subtle, very sensitive policy issues on which reasonable people could disagree. And so I would say, perhaps as a general proposition, the court that succeeded the Wilentz Court may have been somewhat less aggressive, or maybe somewhat less activist, which are words that some people use to describe liberal courts, which I think the Wilentz Court was considered to be. But the court, even as it changed, continued to be a very strong and a very highly regarded state Supreme Court in the grand scheme of state courts around the country. And the current court, which has some new members, Justices Timpone and Solomon are fairly new. Justice Fernandez-Vina probably been there around 4 years. So the current court probably hasn't been together long enough for its judicial philosophy to be clear. We had the benefit, as I said, of 10 uninterrupted years, but it isn't surprising. Somebody once said, it might have been Emerson, that an institution is the lengthened shadow of a man or a woman. And what Emerson meant, I think, is that institutions don't stay the same. It depends who's running them. So the Museum of Modern Art today is a different institution than it was 50 years ago. So is Carnegie Hall, so is the Philharmonic, so is the Metropolitan Opera, so is the Record newspaper. Institutions change as the people who populate them change. And so while our court has a great tradition of excellence and, I think, activism, it really depends on how the current court develops and works together to determine the extent to which they're going to follow along in that in the framework that we were recognized as a court to be.
Just to stick with that for a second, you don't seem entirely comfortable with the term activism. How do you feel about that term as it's used?
Well, I'm
it
personally comfortable with it. I think that it's overused. I think that there are so many circumstances in which courts are required to act because the other branches of government have not. A great example would be the right to die cases. Before the Karen Ann Quinlan case, there was simply no law in New Jersey that would authorize the family of someone who was thought to be brain dead to cut off life support like a respirator. Karen Ann Quinlan was the first case in the country that raised that issue. And of course, the complication is that whoever unplugs a respirator would be susceptible to a charge of some form of homicide because they participated in the death of a live human being. But Karen Ann Quinlan's father, who loved her more than anyone in the world and was her lawful guardian, believed that the respirator should be cut off. And so for the New Jersey Supreme Court under Chief Justice Hughes, former Governor Hughes, it had to decide a question that had been unresolved by the other branches of government. That is it permissible under any circumstances for a respirator to be cut off? My court had to decide whether it's permissible for a feeding tube to be cut off in the case of Nancy Ellen Jobs, in which Ms. Jobs was in an automobile accident. She was diagnosed as being brain dead, but she was being kept alive by a respirator and by a jejunostomy tube by which she was fed. Her husband and her parents brought suit against the care facility in which she was taken care of and asked them to terminate the feeding tube. And the nursing home refused, said this is contrary to our religious faith and we're not going to do it. And besides, we think that there are days that she can hear us and that she nods her head to give an indication that she understands that we're caring for her, so we can't do that. And the case came to our court, and we decided that it was permissible in that circumstance, in an opinion by Justice Garibaldi. It was permissible to terminate the feeding tube. Very difficult. my colleague, Justice O'Hearn, who was of the Catholic faith, dissented. He did not believe it was appropriate for caregivers to terminate feeding, and he wrote a profound dissent, a couple of lines of which went like this: "These may no longer be the people we knew, but they remain the people we loved." And he was reflecting the view that this was simply an act beyond the power of humans and that the law should not sanction it. Our court disagreed and resolved it. Is that activism? I don't think so. I think that we performed a function that no other branch of government could perform. We did it in the most humane, compassionate way that we could, imposed serious restrictions, made absolutely sure that the diagnosis of brain death had been confirmed by independent physicians, made absolutely sure that the family members were acting independently and not for an ulterior motive. But even with those conditions, somebody had to make the call. A similar responsibility was imposed on our court in the school funding cases, which came before the New Jersey Supreme Court from 1970 through my tenure and after, because the other branches of government perfectly well aware that the great cities of New Jersey that used to have the best school systems, like Newark, Jersey City, Paterson, Trenton, and Camden, lost their tax base after the Second World War and could no longer afford to sustain high-quality school systems. They couldn't afford to pay teachers because businesses and residents had moved out of the cities into the suburbs and surrounding communities, and the cities no longer had the tax wealth that they needed to pay for good schools, and New Jersey funded schools through property taxes. And that condition persisted from the 50s to the 90s. And although the Weintraub Court, my court under Chief Justice Weintraub in 1973 or 74, held that the method of funding schools was unconstitutional and had to be fixed, and the legislature stalled and attempted to fix it and tried and failed. Eventually, in Abbott v. Burke in the early 90s, my court, in an opinion by Chief Justice Wilentz, held that the Constitution required that the children that go to urban schools be supported with resources as great as the resources provided to kids in the wealthiest suburban schools, and more, because they came to school with significant limitations, many from single-parent homes, many from homes with incomes below the poverty level, many with homes where they couldn't be exposed to learning at an early age the way other children would. So we ordered free preschool for the 3- and 4-year-olds in those urban school districts. Activist? You know, hundreds of thousands of children were deprived of adequate educations because the legislative and executive branches didn't fix the inequity in school funding that persisted in this state for 4 decades. And so when people turned to the courts and said, look, we can't get relief from the executive or the legislative branches, and this is unfair to hundreds of thousands of kids, you, the judiciary, have a responsibility to say what the Constitution requires. And how could you not conclude that the Constitution required that those kids be given a fair chance? Regrettably, our decisions provided funding. It didn't fix the intense segregation that still exists, because New Jersey today has among the most segregated schools in the entire country. So many of our city schools have individual schools that are more than 99% minority, and many schools that are more than 90% minority. And most of those schools are populated largely by children from families whose incomes are below the poverty level. So although the Robinson, Cahill, and Abbott cases address school funding, they didn't address school segregation. And today, New Jersey's school segregation is worse than in any state in the South. And so, regrettably, we were not called upon to remedy that. But to go back to your question about activism, I think it's the responsibility of the judiciary to decide questions as fundamental as what constitutes a constitutionally adequate education. And if we're presented with evidence, as we were, that the kids in the urban districts had facilities and resources and teachers and course offerings that were demonstrably less adequate than that in the suburban schools, that we had a responsibility to intercede, and that's what we did. So I don't think that's activism, although certainly many people would describe it as activism, but that's the debate. And so we intervened as well in the affordable housing area, because as everybody knows, New Jersey's suburbs for decades had exclusionary zoning ordinances that said that if you want to move into that town, you had to build a single-family house and you had to have at least an acre of property. And of course, if you don't have enough money to buy an acre of property, you can't move into that town, which is why so many minority families and poor families wound up in cities in multiple dwelling residences like apartment houses and not in the suburbs. And so finally, in the Mount Laurel series of cases, our court, before I ever got there, decided that exclusionary zoning ordinances violated the state constitution, and that every municipality in the state had a responsibility to provide for its fair share of low and moderate income housing. Activist? I don't think so. I think that all of the property in the state is in the end state property that needs to be used for the best interest of the citizens. And it's wrong for a community like Saddle River to say, no, you can't live here unless you can afford to buy 2 acres of land. Otherwise, we don't want you. So the function of courts ordinarily is to decide ordinary cases and controversies that arise from accidents, from breaches of contract, from violations of statute. But occasionally courts are asked to intercede in areas where the legislature and the executive branch have stood silent. Mm-hmm. And when that happens, it's my view that the court is obligated to do its job in a thoughtful and responsible and careful way.
Well, do you want to take a break?
No, I'm good.
Okay. You had been on the court for one of the longer periods, I think, in its history, written a record number of opinions. What, of all the cases you dealt with, what are some of the ones that strike you as the most interesting or had the most interesting legal questions at their core?
Yeah, that's hard, Sean. Certainly the school funding cases were very important to me because as a kid who grew up in Irvington, one of the underfunded urban districts in the Abbott case, it was a very personal issue because I understood how Irvington had evolved from a poor blue-collar community to a poor minority community. And I knew that although I didn't get the best education in the world, I got an adequate education, an education that prepared me to go on to college and a law school. And I felt that the kids that were there during the years those funding cases came before us weren't getting the same opportunity I had, and I thought it was wrong. So those cases affected me very personally. Very early on, I believed that free preschool was essential because there was very strong corroborative information indicating that children from these urban districts were getting to kindergarten a year or two behind grade level right at the start. That is, they didn't have the skill set that kindergarten kids in the suburbs had. And it seemed to me that if you were going to give them a fair shot at succeeding, you needed to provide them with early childhood education of a very high quality that would give them a chance to start at the same starting line as the other kids. So I was very happy when the court was able to assemble a majority of its members to order the state to provide free preschool for 3- and 4-year-olds in the urban districts. And at first, the Whitman administration did not comply. Instead of providing high-quality preschool, it provided daycare and called it preschool. And that upset me very much because that wasn't what we had in mind. What we had in mind was high-quality preschool with a trained teacher and an aide and a class of no more than 15 kids and a curriculum that was designed to prepare these young kids for kindergarten, for first grade, to give them a head start in basic skills that they would need to succeed in school. The evidence is overwhelmingly clear that children who are afforded an excellent preschool opportunity do better in public school along the way. And so we ordered several times that the Commissioner of Education come forward with remedial programs designed to help the kids in the cities, and the Commissioner stonewalled us until finally we assigned a judge, Judge King from the Appellate Division, to be a special master to conduct a hearing to determine what extra programs and facilities were needed by the urban school districts for the kids to succeed. And then, and only then, during that hearing, did the commissioner come forward and say, okay, we need preschool. And then we were able to order that preschool be implemented. There's probably 50,000 kids today in the cities in New Jersey that are getting free preschool. I wish it were more. I wish it were expanded throughout the state. It's expensive. Probably costs $10,000 a kid. But it's money well spent if the state can afford it. And the kids in the urban districts benefited from it. Other cases that I remember today, there are not a lot of them. I wrote, 500 or 600 opinions. I happened to be the senior justice on the court when the Trantino case came before us. I forget when, maybe my last year or so, 2000, 2001. And Thomas Trantino, in case you don't know it, was a guy who, as a young man, brutally shot and killed 2 Lodi police officers here at a bar in Lodi. Mm-hmm. He was sentenced to death, but then the death penalty was declared unconstitutional by the United States Supreme Court. So his sentence was commuted to 25 years to life, and he was the longest serving state prisoner in our state correctional facilities. And Trantino turned out, after being a wild, vicious young man, turned out to be somewhat of a model prisoner who mentored other prisoners, became a painter, never got into trouble in prison, had a great record, and every time he would come up for parole, his parole would be denied. And the parole board obviously didn't want to parole him. There was tremendous pressure from the families of the deceased policemen, from the Lodi Police Department, from other Bergen County police departments, from legislators in Bergen County. Tremendous pressure to keep Thomas Trantino in jail. And so the parole board would turn handsprings to find a way to find an excuse, any excuse, to keep him locked up. Case came to our court, I forget how many times. Finally, when they had run out of ways to keep him there, and they were at the end of their rope, and they came up with a couple of more excuses for why they couldn't parole him. The case came to my court. Chief Justice Poritz had to disqualify herself because she had been the Attorney General during prior appeals, and that meant that at the time I was the senior Associate Justice, and so I assigned the opinion to myself, and I wrote it, and made a lot of people in Bergen County unhappy, but nevertheless it was an opinion I felt I had to write, and to my knowledge, he's done okay. He's been out on parole, I think, 15 some years, and I think he's done all right. But that was a hard one. It was a hard one because I remembered the murders. I had lived here when they occurred. I felt they were brutal, totally unjustified, and yet under our parole law, it was clear that Trantino had satisfied all of the conditions of parole, and so the law said that he had to be set free. And I understood how unhappy that would make the families of the deceased cops and the Lodi police officers, but I had no choice but to write the opinion in the manner that the law required. So that was one that I remember vividly. All of the members that served on my court remembered the Baby M case because it attracted international attention. I didn't get to write that opinion. Chief Justice Wilentz did. I thought his opinion was correct, and I thought the court dealt with the issue of surrogate mothers in a fair and effective way. One of the opinions that I wrote that was among the most difficult and one that I was reasonably proud of involved an insurance case brought by the Morton Chemical Company, and it concerned a clause that the insurance companies had developed called the Pollution Exclusion Clause, which in effect said that insurance policies that had that clause wouldn't cover any damages that a company sustained because of pollution of property or water unless the discharge of the pollutants was sudden and accidental. And the reason the case was so significant is that when the insurance companies had written that clause, the Pollution Exclusion Clause, and they submitted the clause to the New Jersey State Insurance Department and to insurance departments around the country, they accompanied the language with a memorandum that said, this is not a major change in our policies. This is a minor change. It just clarifies the policy to make it clear that there's no coverage for deliberate pollution. That was a lie. It was a major change. It was a sea change in coverage. It changed the coverage of most environmental insurance policies from policies that would cover, for example, a company that, unbeknownst to us, had an oil leak that was contaminating adjacent property, and the oil was leaking for 8 years, and the cost of cleanup was in the millions of dollars, but the company was unaware of it, but the leak couldn't be said to be sudden and accidental, so it wouldn't be covered by the Pollution Exclusion Clause. And when the insurance companies submitted this clause to the regulatory agencies throughout the country, they never said, we're reducing coverage, so we're going to cut our rates. Instead, they lied. They said, this doesn't change coverage, it just clarifies it to continue coverage as it is. Had they been honest, the insurance regulators would have required them to reduce the premiums, but they didn't. And so when this case came to our court, there had been hundreds of cases around the country that had been affected by these clauses in insurance policies. And dozens of courts had wrestled with the meaning of the terms sudden and accidental. Was something sudden an event that happened and ended immediately? Was that sudden? Or could there be a leak that was sudden but that lasted for 3 months afterwards? What did it mean to be accidental? And the law was so complicated around the country, and we had lawyers from all kinds of insurance companies participating in the case, and the opinion was assigned to me, and my court agreed at the conference that we wouldn't enforce the clause because the insurance companies lied when they submitted it to regulators and misled the regulators about what it meant. And we construed the clause only to deny coverage if pollution was deliberate, intentional. Otherwise, we said it was covered, and we, in effect, rewrote the clause to mean what the insurance companies had said it meant. So I took a look at that opinion the other day, and it was a tough one to write because there were so many cases around the country that I had to read and review and wrestle down. But I was delighted that I had a unanimous court behind me when I wrote it. I don't think that opinion made me particularly popular in the insurance industry, and I'm sure there are insurance executives that still remember Stein as the guy that wrote that Morton International opinion, but I thought that was one of the more challenging opinions I wrote.